Morning. Welcome to today's episode of Legally Raven Hair. We have been away for 2 weeks because we were writing a short story for a competition. So now we're back to reading civil procedure in the mornings. Mullane v. Central Hanover Bank, the constitutional standard for adequate notice. The federal constitution bars the states and the federal government from taking a person's life, liberty, or property without due process of law. U.S. Constitution amends 5:14. U.S. amends 5 and 14. When a court enters a judgment against the defendant, it interferes with the defendant's liberty or property, so it must act in accordance with due process of law in reaching its decision. This broad phase encompasses several protections for litigants, including the requirement that the court have personal jurisdiction over the defendant and that it use judicial procedures in processing the case and reaching a decision. Certainly, one component of fair procedure is the common sense requirement that the defendant be adequately informed that the court intends to adjudicate her rights. Mullane v. Central Hanover Bank and Trust Company, the case below articulates basic constitutional standards for adequate methods of service of process. Reading Mullane v. Central Hanover Bank and Trust, some background on the Common Trust Fund device will help you understand Mullane. The Common Trust Fund allows banks to invest the assets of many small trusts in one fund, achieving economies of scale, minimizing expenses. Each individual trust would then share in the earnings or losses in proportion to the amount it invested in the common fund. The New York statute authorizing common trust funds requires banks to obtain court approval of the financial accounts of a common trust fund to assure the bank was administering the funds properly. If the court approved the accounts, its judgment will bind anyone with an interest in the trust. Consequently, a beneficiary who thought the bank had invested unwisely, depleting the common trust fund, and hence the value of the beneficiary's interest, will be barred from suing the bank for mismanagement. Thus, the accounting could deprive a beneficiary of property, her right to sue the bank for malfeasance. Hence, the 14th Amendment Due Process Clause require adequate notice of action to those with an interest in the fund. Giving individual notice to all those with an interest in a common trust fund is like the one in Mullane would be almost impossible. An individual trust might call for payment of the income to A, then to A's spouse after her death, and then to their children. The trust might provide if A survives the spouse, the income and the principal will be paid to the children at A's death, or if any child's died, the children's children. If she dies childless, it might provide the income and principal will go to the siblings and principals, or if they predeceased A, then A's heirs. So a lot of people may have contingent interest in trust. They might be entitled to the income or principal of the trust at some point in the future. If Mullane, the bank estimated that about 5,000 people might have interest in the commingled trust, and that the expense in hiring investigators and lawyers to identify all interested persons would make it financially impossible to use common trust fund advice. In reading Mullane, consider these questions. How did the bank notify persons with an interest in the trust? Why did it use that method of notice? Why did the court hold that action notice were required for different categories of persons with an interest in the trust? Did the court approve notice by publication for any persons with an interest in the trust? Because Mullane is a complex opinion, we have inserted some editorial comments in brackets to act as guideposts along the way. Mullane v. Central Hanover Bank and Trust. Mr. Justice Jackson delivered the opinion of the court. This controversy questions the constitutional sufficiency of notice to beneficiaries on judicial settlement of accounts by the trustee of a common trust fund established under the New York Banking Law, Council Laws C2. The New York Court of Appeals considered and overruled objections that the statutory notice contravenes requirements of the 14th Amendment, and that by allowance of the account, beneficiaries were deprived of property without due process of law. The case is here on appeal under 28 U.S.C. Section 1257. Common trust fund legislation is addressed to a problem appropriate for state action. Mounting overheads have made administration of small trusts undesirable to corporate trustees in order that donors and legislators of moderately sized trusts may not be denied the service of corporate fiduciaries. The District of Columbia and some 30 states other than New York have permitted pooling small trust estates into one fund for investment administration. The income, capital gains, losses, and expenses of the collective trust are shared by the constituent trust in proportion to their contribution. By this plan, diversification of risk and economy of management can be extended to those whose capital standing alone will not obtain such advantage. Here, the court describes the common trust fund device and a particular fund established by the bank to jointly manage the group of small trusts. Statutory authorization of the establishment of common trust funds is provided in the New York banking law. Under this act, the trust company may, with approval of the state banking board, establish a common fund and, within prescribed limits, invest their assets of an unlimited number of estates, trusts, or other funds of which it is trustee. Each participating trust shares ratably in the common fund, but exclusive management of the control is in the trust company as trustee. And neither a fiduciary nor a beneficiary of a participating trust is deemed to have ownership in a particular asset or investment of the common trust this common fund. The trust company must keep fund assets separate from its own and in its fiduciary capacity may not deal with itself or an affiliate. Provisions are made for accounting 12 to 15 months after the establishment of the fund and triennially thereafter. The decree in such judicial settlements of accounts is made binding and conclusive as to any matter set forth in the account upon everyone having an interest in the common fund or in any participating estate, trust, or fund. In January 1946, Central Hanover Bank and Trust Company established a common trust fund in accordance with these provisions, and in March 1947, it petitioned the surrogate court for settlement of its first account as common trustee. During the accounting period, a total of 113 trusts, approximately half inter vires and half testamentary, participated in the common trust fund, the gross capital of which was nearly $3 million. The record does not show the number or residence of beneficiaries, but they were many, and it is clear that some of them were not residents of the state of New York. The fund was required by the New York statute to provide notice to account settlement procedures to those with an interest in the fund. Note how it gave notice. The only notice given beneficiaries of the specific application was by publication in the local newspaper in strict compliance with the minimum requirements of the New York banking law. After filing such a petition for judicial settlement of its account, the petitioner shall cause to be issued by the court in which the petition is filed and shall publish not less than once in each week for 4 successive weeks in a newspaper to be designated by the court, a notice of citation addressed generally without naming them to all parties interested in such common trust funds and in such estates, trusts, and funds mentioned in the petition, all of which may be described in the notice of citation only in the manner set forth in said petition and without setting forth the residence of any such decedent or donor of such estate trust fund. Thus, the only notice required and the only notice given was by newspaper publication, setting forth merely the name, address of the trust company, the name and date of the establishment of the common trust fund, and the list of all the participating estates, trusts, or funds. At the time, the first investment in the common fund was made on behalf of each participating estate. However, the trust company, pursuant to the requirements of 100C9, had notified by mail each person of full age and sound mind whose name and address was shown to it and who was entitled to share in the income therefrom, or who will be entitled to share the principal in if the event which such estate trust fund will be distributable should have occurred at the time, who would be entitled to share in the principal if the event upon which such estate trust or fund will become distributable should have occurred at the time of sending such notice. Included in the notice is a copy of those provisions of the Act relating to the sending of the notice itself and the judicial settlement of common trust fund account. Because many persons with contingent interest in the common trust fund will probably not receive the notice of accounting, the New York statute provided an alternative means of protecting the interest of such person. Upon the filing of the petition of the settlement of the accounts, the appellant was, by order of the court, pursuant to 100C12, appointed special guardian and the attorney for all persons known or unknown, not otherwise appearing, who had or might thereafter have interest in the income of the common trust fund. The appellee Vaughn was appointed to represent those similarly interested in the principle. There was no appearances in behalf of any interested in either interest or principle. Appellant appeared specially objecting that notice and the statutory provisions for notice to beneficiaries was inadequate to afford due process under the 14th Amendment, and therefore the court was without jurisdiction to render a final binding decree. Appellant's objections were entertained and overruled. The surrogate holder that the notice required and given was sufficient. A final decree accepting the accounts had been entered, affirmed by the appellate division of the Supreme Court and by the Court of Appeals of the State of New York. The effect of this decree is held below is to settle all questions respecting the management of the common fund. We understand that every right which beneficiaries will otherwise have against the trust company, either as trustee of the common fund or as trustee of the individual trust for improper management of the common trust fund during the period covered by the accounting, is sealed and wholly terminated by decree. Mullane, a special guardian for the investors, argued that the action was in personam because it would affect the right of each investor to sue the bank for negligence. Thus, he argued that personal jurisdiction must be attained over each investor. The bank argued that the action was in rem because the trust was before the court so that it could settle rights of all claimants of the trust assets before it. The court, however, refused to make the due process standard for adequate notice turn on the in rem and personal distinction. We are met at the outset with a challenge of the power of state, the right of its courts to adjudicate at the same time as adjudicate at all as against those beneficiaries who reside without the state of New York. It is contended that the proceeding is one in person in that the decree affects neither title to possession of any res, but adjudges only personal rights of the beneficiaries to surcharge the trustee for negligence and breach of trust. Accordingly, it is said under the strict doctrine of familiar venef, the surrogate is without jurisdiction as to non-residents upon whom personal service of process was not made. Distinctions between actions in rem and those in personam are ancient and originally expressed in procedural terms. What seems to really have been a distinction of substantial property under a system quite unlike our own. The legal recognition and rise of economic importance of incorporeal or intangible forms of property have upset the ancient simplicity of property law and the clarity of its distinctions, while new forms of proceedings have confused all procedure classifications. American courts have sometimes classed certain actions as in rem because personal service of process was not required, and at times have held personal service of process not required because the action was in rem. Judicial proceedings to settle fiduciary accounts have been sometimes termed in rem, or more definitely quasi in rem, or more vaguely still in the nature of proceeding in rem. It is not readily apparent how the courts of New York did or would classify the present proceeding, which has some characteristics and is wanting in some features of proceeding both in rem and in person. But in any event, we think that the requirement of the 14th Amendment to the Constitution do not depend on the classification for which the standards are so elusive and confused generally, and which, being primarily for state courts to define, may and do vary from state to state without disparaging the usefulness of distinctions between actions in rem and those in person in many branches of law or on other issues, or the reasoning which underlies them. We do not rest the power of the state to resort to constructive service in this proceeding upon how its courts or this court may regard this historic antithesis. It is sufficient to observe that whatever the technical definition of this chosen procedure, the interest of each state in providing means to close trust that exists by the grace of its laws and are administered under the supervision of its courts is so insistent and rooted in custom as to establish beyond a doubt the rights of its court to determine the interests of all claimants, resident or non-resident, provided its procedure accords full opportunity to appear and be heard. The court notes that approval of the accounts may deprive trust beneficiaries of property by cutting off their right to sue the bank for mismanagement that depletes the value of its trust. Quite different from the question of a state's power to discharge trustee is that of the opportunity it must give beneficiaries to contest. Many controversies have raged about the cryptic and abstract words of the Due Process Clause, but there can be no doubt that at minimum they require that deprivation of life, liberty, and property by adjudication be preceded by notice and opportunity for hearing appropriate to the nature of the case. In two ways, this proceeding does and may deprive beneficiaries of property. It may cut off their rights to have the trustee answer for negligent or illegal impairment of their interests. Also, their interests are presumably subject to diminution in the proceeding by allowance of fees and expenses to one who, in their names but without their knowledge, may conduct a fruitless or uncompensatory contest. Certainly, the proceeding is one in which they may be deprived of property rights, and hence notice and hearing must measure up to the standards of due process. Now the court gets down to business of reconciling two values, the bank and the investor's interest in making it practical to use common trust fund, and the investor's interest in adequate notice of the settlement proceedings. Personal service, i.e. in-hand delivery of written notice within the jurisdiction, is the classic form of notice, always adequate in any type of proceeding. But the vital interest of the state in bringing any issue as to its fiduciaries to a final settlement can be served only if interests or claims of individuals who are outside the state can somehow be determined. A construction of the Due Process Clause, which would place impossible or impractical obstacles in the way, could not be justified. Against this interest of the state, we must balance the individual interest sought to be protected by the 14th Amendment. This is defined by our holding that the fundamental requisite of due process of law is the opportunity to be heard. Grandis v. ordained. The right to be heard has little reality or worth unless one is informed that the matter is pending and can choose for himself whether to appear or default, acquiesce, or contest. The court has not committed itself to any formula achieving a balance between these interests in a particular proceeding or determining when constructive notice may be utilized or what test it must meet. Personal service has not in all circumstances been regarded as indispensable to the process due to the residents. It has more often been held unnecessary as to non-residents. We disturb none of the established rules on these subjects. No decision constitutes a controlling or even a very illuminating precedent for the case before us, but a few general principles stand out in the books. The court next expounds the basic constitutional standard for adequate notice. An elementary and fundamental requirement of due process in any proceeding, which is to be accorded finality, is notice reasonably calculated under the circumstances to appraise interested parties of the pendency of the action and afford them an opportunity to present their objections. Milliken v. Meyer, 311 U.S. 457, the notice must be of such nature as reasonably to convey the required information, and it must afford a reasonable time for those interested to make their appearance. But if with due regard for the practicalities and peculiarities of the case, these conditions are reasonably met, the constitutional requirements are satisfied. The criterion is not the possibility of conceivable injury, but the just and reasonable character of the requirements having reference to the subject with which the statute deals. America Land Company v. This, 219 U.S. 47. But when notice is a person's due process, which is a mere gesture. But when notice is a person's due process, which is a mere gesture, is not due process. But when notice is a person's due process, which is mere gesture, is not due process. But when notice is a person's due process, which is just mere gesture, is not due process. The means employed must be such as one desires of actually informing the absentee might reasonably adopt to accomplishment. The reasonableness and hence the constitutional validity of any chosen method must be defended on the grounds that it is in itself reasonably certain to inform those affected, or where conditions do not reasonably permit such notice, that the form chosen is not substantially less likely to bring home notice than other of the feasible and customary substitutes. The court discusses here the problems with constructive service of process by publication. It would be idle to pretend that publication alone, as prescribed here, is a reliable means of acquainting interested parties with the fact that their rights are before the courts. It is not an accident that the greater number of cases reaching this court on the question of adequacy of notice have been confirmed with actions founded of process constructively served through local newspapers. Chance alone brings chance alone brings to the attention of even Chance alone brings to the attention of even a local resident an advertisement in small type inserted in the back pages of a newspaper. And if he makes his home outside the area of the newspaper number circulation, the odds that the information will ever reach him are large indeed. The chance of actual notice is further reduced when, as here, the notice required does not even name those whose attention it is supposed to attract and does not inform acquaintances who might call it to attention. The weighing its sufficiency on the basis in weighing its sufficiency on the basis of equivalence with actual notice, we are unable to regard this as more than a fact. Nor is publication here reinforced by steps likely to attract the party's attention to the proceeding. It is true that publication traditionally has been acceptable as notification supplemental to other action, which in itself may reasonably be expected to convey a warning. The ways of an owner with tangible property are such that he usually arrange means to learn of any direct attack upon his possessory or prepare or proprietary rights. Hence, libel of a ship, attachment of a chattel, or entry upon real estate in the name of law may reasonably be expected to come promptly to the owner's attention. When the state within which the owner has located such property seizes it for some reason, publication or posting affords an additional measure of notification. A state may indulge the assumption that one who has left tangible property in the state either has abandoned it, in which case proceeding against it deprive him of nothing, or that he has left some caretaker under a duty to let him know what is being jeopardized. In the case before us, of course, no abandonment. In the case before us, there is, of course, no abandonment. On the other hand, these beneficiaries do have a resident fiduciary or caretaker of their interest in this property, but it is their caretaker who in this accounting becomes their adversary. The trustee is released from giving notice of jeopardy, and no one else is expected to do so. Not even the special guardian is required or apparently expected to communicate with his ward and client. And of course, if such a duty were merely transferred from the trustee of the guardian, economy would not be served and more likely the cost would be increased. The court has not hesitated to approve of resort to publication as a customary substitute in another class of cases where it is not reasonably possible or practical to give more adequate warning. Thus, it has been recognized that in the case of persons missing or unknown, employment of an indirect or even probably futile means of notification is all that the situation permits and creates no constitutional bar to a final degree foreclosing their rights. The court has not hesitated to approve of resort of publication as the customary substitute. The court has not hesitated to approve. This court has not hesitated to approve of resort to publication as a customary substitute in other class of cases where it is not reasonably possible or practical to give more adequate warning. Thus, it has been recognized that in the case of persons missing or unknown, employment of an indirect and probably even futile means of notification is all that the situation permits and creates no constitutional bar to a final degree foreclosing their rights. Next, the court applies the basic constitutional standard to various classes of person with an interest in the trust. Those beneficiaries represented by appellant whose interest or whereabouts could not with due diligence be ascertained come clearly within this category. As to them, the statutory notice is sufficient. However, great the odds that publication will never reach the eyes of such unknown persons. As to them, the statutory notice is sufficient. However, great the odds that publication will never reach the eyes of such unknown persons. It is not in the typical case much more likely to fail than any of the choices open to legislators endeavoring to prescribe the best notice practicable. Nor do we consider it unreasonable for the state to defense with more certain notice to those beneficiaries whose interests are either conjectural or future, although they could be discovered upon investigation, do not, in the due course of business, come to knowledge of the common trustee. Whatever searches might be required in another situation under ordinary standards of diligence. In view of the character of the proceedings and the nature of the interests here involved, we think them unnecessary. We recognize the practical difficulties and costs that would be attendant on frequent investigations into the status of a great number of beneficiaries, many of whose interests in the common fund are so remote as to be ephemeral. Ephemeral. Like that's not sure. Ephemeral. Are so remote as to be ephemeral. And we have no doubt that such impracticable and extended searches are not required in the name of due process. The expense of keeping informed from day to day of substitutions among even current income beneficiaries and presumptive remainder men, to say nothing of the far greater number of contingent beneficiaries, will impose a severe burden on the plan and will likely dissipate its advantages. These are practical matters in which we should be reluctant to disrupt the judgment of the state authorities. Accordingly, we overrule appellant's constitutional objections to publish notice insofar as they are urged on behalf of any beneficiaries whose interests or addresses are unknown to the trustee. Okay, so if you don't know their address or interest, then fine, you can give published notice. As to known present beneficiaries of known place of residence, however, notice and publication stands on a different footing. Exceptions in the name of necessity do not sweep away the rule that within the limits of practicability, notice must be given as reasonably calculated to reach interested parties. Where the names and post office addresses of those affected by the proceeding are at hand, the reasons disappear to resort to means less likely than the mails to apprise them of pendency. The trustee has on his book the names and addresses of the income beneficiaries represented by appellant, and we find no tenable ground for dispensing with a serious effort to inform them personally of the accounting, at least by ordinary mail to the record addresses. Certainly sending them a copy of the statute months and perhaps years in advance does not answer this purpose. The trustee periodically remits their income to them, and we think that it might reasonably expect that with or apart from their remittances, word might come to them personally that steps are being taken affecting their interests. We need not weigh contentions that a requirement of personal service of citation on even the large number of known resident or non-resident beneficiaries would, by reason of delay, if not of expense, seriously interfere with the proper administration of the fund. Of course, personal service, even without the jurisdiction of the issuing authority, serves the end of actual and personal notice, whatever power of compulsion it might lack. However, no such service is required under the circumstances. This type of trust presupposes a large number of small interests. The individual interest does not stand alone, but is identical with that of a class. The rights of each in the integrity of the fund and in the fidelity of the trustee are shared by many other beneficiaries. Therefore, notice reasonably certain to reach most of these interested in objecting is likely to safeguard the interest of all, since any objection sustained would inure the benefit of all. We think that under such circumstances, reasonable risk that notice might not actually reach every beneficiary is justifiable. Now and then an extraordinary case may turn up, but constitutional law, like other mortal contrivances, has taken some chance. Contrivance, the use of skill to bring something about. Contrivance. Contrive. Okay. Constitutional law, like other mortal contrivances, has has to take some chances, and in the great majority of instances, no doubt justice will be done. Boone v. Nelson. The statutory notice to known beneficiaries is inadequate, not because it fails to reach everyone, but because under the circumstances, it is not reasonably calculated to reach those who could easily be informed by other means at hand. However, it may have been in former times. The mails today are recognized um, as an efficient and inexpensive means of communication. Moreover, the fact that the trust company has been able to give mail notice to non beneficiaries at the time the Common Trust Fund was established is persuasive that postal notification at the time of accounting would not seriously burden the plan. In some situations, the law requires greater precautions in its proceedings than the business world accepts for its own purposes. In a few, if any, will be satisfied. In few, if any, will be satisfied with less. Certainly, it is instructive in determining the reasonableness of the impersonal broadcast notification here used, to ask whether it would satisfy a prudent man of business, counting his pennies, but finding it in his interest to convey information to many persons whose names and addresses are in his files. We are not satisfied that it would. Publication may theoretically be available for all the world to see, but it is too much in our day to suppose that each and every individual beneficiary does or could examine all that has been published to see if something may be tucked away in it that affects his property interest. We have before indicated in reference to notice by publication that great caution should be used not to let fiction deny the fair play that can be secured only by a pretty close adhesion to fact. McDonald v. Maybe. We hold the notice of judgment settlement of accounts required by the New York banking law is incompatible with the requirements of the 14th Amendment as a basis for adjudication, depriving known persons whose whereabouts are also known of substantial property rights. Accordingly, the judgment is reversed and the cause remanded for further proceedings not inconsistent with this opinion. Nelson questions on Mullane v. Central Bank. The holding of Mullane, what exactly did the Mullane case hold? Consider the question below. Yes, we answer our question with the question, a typical law school boy. In Mullane v. Central Hanover Bank and Trust, the Supreme Court held that every person with the current right to income from the trust is entitled to at least a mailing notice of the proceeding. Every person whose name and address can be ascertained through investigation may be given individual notice of proceeding. Any person whose interest might be affected by the proceeding must be given notice by in-hand service and process. Due to the large number of persons whose interest might be affected by the proceedings, notice by publication was sufficient on the facts in the case. Now, if anybody whose address on record, A is not right. The court did not hold the bank must provide mail notice to current income beneficiaries whose names and addresses. The court did hold that the bank must provide mail notices to current income beneficiaries whose name and addresses have been filed. That is easy to do and cheap, but since these trusts were established, the right to current income may have shifted to new beneficiaries if the children were born or married, or the settlor of the trust died, or for some other reason, Mullane recognized that requiring the bank to do legal and factual research to identify and locate such persons was impractical. Since the expense of doing so would eat up the profits of the trust, so some current beneficiaries whose names and addresses would not be in the bank's records did not have individual notice. He also fails for the same reason. It suggests that the bank would have to conduct investigation to determine all persons having interest in the combined trust and give them individual notice. The Mullane opinion declines to impose that be burden on the bank. He is also not agreement Mullane did not require any beneficiary to be served in hand. The opinion approves service by mail of known beneficiaries for whom the bank had addresses on file. D is also not entirely right. Mullane held that publication notice suffice as to many persons with an interest in the proceeding, but not to all. For those whose names are in the bank's files, at least notice by mail is constitutionally required. Notice by publication would not constitute due process for those beneficiaries because a better method of notice was readily available. Mullane upholds notice by publication under New York statute together with the appointment of guardians required by the statute as constitutionally sufficient to notify beneficiaries whose names and address were not known by the bank. So the prize goes to E. Service by the book. In Mullane, the method of service of processing for the accounting procedure was set forth in detail in the New York statute governing common trust funds. The bank, in seeking approval of its accounts, complied with the statutory procedure. So what's the problem? The problem is that the state notice statutes must specify a method of notice that is constitutionally sufficient under the due process clause of the 14th Amendment. The method used must both be authorized by the applicable statutes or rules governing service in a particular court and also meet constitutional standards. The fact that a statute authorizes a particular method of service does not automatically make it proper. This is similar to the relation between a state long-arm statute and the 14th Amendment. Even if a long-arm statute authorizes personal jurisdiction, it cannot be exercised if it would exceed due process limits. New York banking law dealing with settlement of common trust funds now contains detailed requirements for mail notice to various categories of persons to whom the bank has knowledge and who might have an interest in trust. The point reiterated, a statute that failed to pass constitutional muster. Green v. Lindsay, 1982, involved service of process in an eviction action. A Kentucky statute authorized the sheriff to deliver the notice to the tenant, or if no one was home, to post the papers on the tenant door. This statute was challenged by tenants in federal court, claiming that the statutory method of serving process did not satisfy minimum standards of constitutionally adequate notice described in Mullane v. Central Hanover Bank. The Supreme Court agreed with the tenants' argument. The problem was that many such notices did not reach the defendants whose tenancy were at risk. As the process servers were welfare, notices posted on apartment doors were not infrequently removed by children or other tenants before they could have their intended effect. Under these conditions, notice by posting on the apartment door cannot be considered a reliable means of acquainting interested parties of the fact that their rights are before the courts. The other side of the constitutional coin was that a reliable and inexpensive means of enhancing the likelihood of actual notice was available, dropping a second copy of the papers in U.S. mail addressed to the tenant at the rental address. Because the method used was not sufficiently likely to reach the tenants and an easy means of providing more effective services available. The court held the statutory posting procedure constitutionally inadequate under Mullane. And another, Jones v. Flowers, an Arkansas statute authorized notice of a tax sale proceeding by certified mail to the owner of the property, followed by publication if the letter was returned unclaimed. The Supreme Court, in a closely divided opinion, held this notice inadequate under Mullane. We conclude that someone who actually wanted to alert Jones that he was in danger of losing his house would do more when the attempted notice letter was returned and claimed, and there was more that reasonably could be done. The majority relied in part on the extent of the deprivation involved, sale by the court of the defendant's real estate, and in part on the fact that several additional steps would be likely to give actual notice of the taking, including posting a notice on the property or regular mail notice to the occupant of the property. See also Mennonite Board of Mission v. Adams, 1983 statute authorizing notice to sell a property by publication and posting held unconstitutional or delay. Okay. We could have certified mail, but if they weren't home, they had to go to the post office to pick it up. So we claims you could also send a regular mail, you could also post it. Is last and unusual service constitutional? Federal Rule 4E2B allows service by leaving the summons and complaint if the defendant is the person at the defendant's dwelling with a person of suitable age and discretion residing therein. However, some states allow service of process by leaving copies of the summons and complaint at the defendant's last and usual place of abode without the additional requirement of leaving them with the person residing there. Massachusetts Civil Procedure 4D1. What is the argument that this method of service is unconstitutional under Mullane? This provision appears to allow service by simply slipping papers under the door. This is considerably less likely to assure actual notice than delivery to a person. Indeed, it would appear that this rule would be met by posting the papers on the defendant's door, the procedure rejected in green. The papers might somehow get lost or picked up by someone else. At the same time, there is a convenient means of improving the likelihood of actual notice, mailing copies to the defendant at the address. The provision has been in effect in Massachusetts for many years, but counsel may be wise. This provision has been in effect in Massachusetts for many years, but counsel may be wise to use one of the other methods authorized in the rule, such as personal delivery, to avoid the risk of a constitutional challenge. For a rule that avoids the constitutional problem, see Index R Trial Procedure Rule 41B, which requires mailing the summons to the defendant after leaving the summons and complaint at her usual place of abode. See also Kansas statute section 60-303B, requiring mail notice that summons and complaint have been requiring mail notice that summons and complaint have been left at the usual place of abode. So, how must notice be given to satisfy the due process clause? It would be nice to give a single simple answer to this question, but the types of proceeding, types of defendants, and the circumstances in which notice is attempted vary too much to allow one. This means required by due process. This means required by due process must vary with circumstances. Thus, Mullane establishes a broad constitutional standard rather than providing a mechanical answer. The standard Justice Jackson suggests is an eminently sensible one. When notice is a person's due process, which is a mere gesture. When notice is a person's due process, which is a mere gesture, is not due process. This means the means employed must be one such that desirous of action must be such as one desirous of actually informing the absentee, right? The means employed must be such as one desirous of actually informing the absentee might reasonably adopt to accomplishment. Means employed must be such as one desirous of actually informing the absentee might reasonably adopt. Employee must be such as one desirous of actually informing the absentee. So basically, you have to use a process that actually has the possibility of informing the person, or that shows that you actually want to inform the person, not that you're just trying to get, not that you're just trying to get over on them, basically. Justice Robert Jackson lived from 1892 to 1954, was raised in New York State. He never went to college. He apprenticed in a law office, attended 1 year of law school, and passed the New York bar at the age of 21. He became an eminent practitioner and advisor to President Franklin D. Roosevelt. During the Roosevelt administration, he served in the Justice Department, was appointed Solicitor General of the United States, then Attorney General of the United States, where he aggressively pursued the policies of the New Deal. He was appointed to the Supreme Court in 1941. He also served as the chief prosecutor at the Nuremberg trials, at which Nazi officers were prosecuted for war crimes during World War II. His opinion in Mullane, like several other classics he penned on procedure issue, reflects his good judgment and grasp of the practicality of law practice. Adequate service in an ordinary case. Johnson sues Fuentes, an individual who owes her some money. Based on the discussion of constitutional standards in Mullane, which of the following methods would you expect the court to find constitutionally adequate? In-hand service, personal delivery of the summons and complaint on Fuentes by sheriff, in-hand service of the summons and complaint on Fuentes by Johnson, mailing of the summons and complaint to Fuentes at his home address by certified mail, mailing of the summons and the complaint to Fuentes at his home by first class mail, publication of notice of the filing of the action in the local newspaper for 3 weeks in a row, posting of a notice of the suit on a bulletin board for the bar so cases filed. In-hand service, personal delivery by sheriff, personal delivery papers notifying Fuentes of the suit of his duty to defend. It is the best possible form of notice. The person giving notice physically confronts the defendant and hands him papers delivering the bad news. This is about as good as notice gets, and 1 and 2. So 1 and 2 should pass the constitutional muster. Oh, 2 as well. Federal bar is the process by a party. Service of process by a party, perhaps to avoid physical confrontations of the parties. However, nothing in the line starts with the provincial limit is constitutional order. Okay, so you can the party can't deliver the party. However, nothing in Mullane suggests that this prudential limit is constitutionally required. Oh, yeah, civil procedure says you can't, that the parties involved can't do it, but Mullane doesn't say that that's constitutionally inappropriate. It was a civil procedure, summons. The plaintiff may present a summons to the clerk of seal. If the summons is properly completed, the clerk must sign, seal, and issue to the plaintiff for service of defendant a summons or a copy of a summons that is addressed to multiple defendant must be issued for each defendant and served. Service in general, serve copy of the complaint by whom any person that is 18 years old and not a party may serve a summons in the complaint. So that's where it is, civil procedure. All right, great. Let's go back to where we were. Okay, it passes constitutional muster, number 2, although it is not in harmony with civil procedure. Methods 3 and 4, use of U.S. mail to give notice. Justice Jackson's opinion suggests that it is generally constitutional proper when papers are mailed to the current address for the defendant. However, method 5 is constitutionally defective if Johnson can do something better. Surely a business person trying to contact a customer will not establish notice in paper if she had the address of the customer. As Mullane suggests, publication is a hit or miss proposition that no one would use if they had sure alternatives. It may be constitutionally sufficient if nothing better can be done, but otherwise it would not suffice. Posting a notice at the courthouse is also a chancy means of reaching the defendant. If you wanted to ask him to pay back a loan, you wouldn't use this method, would you? Again, unless nothing better is feasible because you have no idea where Fuentes is, this is constitutionally deficient. As a working rule, service by mail and personal delivery are constitutionally acceptable, but publication notice is not unless other means have failed. Reasonable investigation. Marino is in an accident with Malowitz. He exchanges information with Malowitz at the accident scene. Later, he brings an action against Malowitz and serves him by mail, but the mailing comes back undeliverable. Based on the analysis of Mullane, may Marino now serve Malowitz by publication? Probably not. And Mullane, the court approved publication notice to various persons of interest in the trust, even though the bank might have found their names and addresses after some of the investigation. But in Mullane, there were many parties with a remote interest in the fund, and the circumstances provided other protections for the interests of those absent beneficiaries. Those who did not get notice had the same interest in making sure that the bank had managed the combined fund appropriately, and 2 special guardians were appointed to protect those interests as well. Here, there is only one person to be located and served, so the expense of trying to locate him would be less than Mullane. And absent personal notice, Malowitz will very likely not learn of the case and protect his rights. Since publication is likely to be a mere gesture, the reasonableness analysis articulated in Mullane clearly calls for more effort to find Malowitz. Okay, yeah, so that makes sense. Okay, C, Gayeth v. Deacon, 2009, rejecting publication notice despite aggressive efforts to locate a defendant. All right, and so that's where we'll stop today. We will pick up on page 342, implementing the due process standard, statutes, and rules governing service of process. We'll pick up there tomorrow.